Hi, I'm Tom Spiegel with the Spiegel Law Firm, where we represent people who've been wrongfully terminated or afraid that they might be. Today, I want to talk to you about the overturning of Bill Cosby's criminal conviction. As I think most of us know, Bill Cosby was criminally convicted a number of years ago in Pennsylvania after a jury trial in which they found that he had basically assaulted a number of women. And he went to jail he was in jail when the case was overturned by the Pennsylvania Supreme Court. And this was understandably a big blow psychologically to the Me Too movement because his conviction was one of the first that ushered in a wave of other convictions. And so the fact that it got overturned is really difficult, certainly not only for the people that were involved in the trial and witnesses against him, but for other women and some men who were hoping that things had changed, hoping that the Me Too movement was going to make a difference. I want to talk to you about why it, of course, is disappointing, but perhaps doesn't have as broad a reach as some people think. First, the Pennsylvania Supreme Court decided this on a technicality that's going to be very unlikely to exist, and really in many cases, certainly probably yours. And the technicality was this. Back in 2010, Bill Cosby was investigated by the district attorney at the time. The district attorney looked at the evidence and decided that he didn't have enough to meet his burden. That is, okay, I've got this evidence that this bad stuff happened. I believe it, but I don't think I can prove to a jury the very high standard of beyond a reasonable doubt. So he decided not to bring criminal charges and then suggested to Bill Cosby, because there was parallel civil litigation going on where these women were suing him, that he would get immunity, that is immunity from prosecution, if he didn't fight being deposed in this underlying civil litigation. So Bill Cosby was deposed. He made a number of incriminating statements in that deposition. Again, this was in the civil trial, not in the criminal trial. And ultimately that case settled prior to trial. Well, fast forward to the time he was prosecuted again, and the court found that because that initial promise had been made, that it was an enforceable agreement, that essentially like the prosecution had said, I'm not going to prosecute you if you participate in this deposition, which he did, and relying upon that made in some incriminating statements, which were then kind of used against him later. And the court was like, essentially that's unfair. That's a due process violation of his constitutional rights, and that the violation was so severe that the only remedy was to completely overturn his conviction. One can, quibble or argue with the court's findings, certainly with a finding that the only remedy that would address this was a complete dismissal. But nevertheless, the point is that this is a unique fact pattern that is not going to exist in many cases. Another thing to remember is the positive side of this, and that is that the decision that prosecutor made in 2010 is not the same decision that most prosecutors would make now. And I say that because in 2010, the prosecutor decided that the evidence wasn't strong enough because one of the key complainants in that case, one of the key victims, didn't immediately report the assault, and also there were some inconsistencies in her statement. And that is one thing that has changed for the better. I used to prosecute sex violence crimes when I was a prosecutor, and things have changed in terms of how juries view this. For instance, it is now well established that a fact that a victim of sexual assault doesn't report immediately has nothing to do with the validity of what happened. They may not report because they're scared. They might not report because they think nothing's going to happen. They may not report because they fear retaliation. There are any number of very understandable reasons why somebody would delay reporting. So today, a prosecutor looking at that same evidence would not hold that against the victim and say, oh, well, she reported late, therefore, while I believe her, I don't think I can get a jury to believe her. Also, inconsistencies within a statement. I mean, this happens in all kinds of cases where there are inconsistencies in whether people mean them or not, and what they remember, particularly about a traumatic event like sexual assault. Again, prosecutors and even juries these days understand that better than they did in 2010. That those who report sexual harassment or sexual assault in a criminal context now are much less likely, I won't say it's impossible, but much less likely to find a prosecutor who's going to hold you to a really high standard, because there was a time where juries were disinclined to believe victims of sexual assault. That's not That's not true now, so I think a decision like that would not be made today. It's also important to remember that if you're watching this and you have been the victim of sexual harassment in the workplace or sexual assault or know someone who has, that not every case involves criminal charges. In fact, most don't. And if you bring a case forward in a civil context, there's probably not going to be a criminal trial unless you go, a criminal prosecution, unless you go to the prosecutor and report that. Again, whether you do that or not, something you want to talk to your attorney about. It sort of depends on what the conduct was like, because there are some advantages and different disadvantages to when you report, how you report, and how those claims are handled separately. It can get very complicated. But the truth is that the vast majority of these cases, there's not going to be an underlying criminal trial. It's just going to be a civil matter. So what was underlying the Cosby case is not going to be a factor in most sexual assault, sexual harassment cases, and indeed in many of the cases that were brought forward under the Me Too movement.